Welcome to Deb's True Crime Notebook, where we read the documents for you so you don't have to. So we have the prosecution's response to the motion to preserve evidence. Let's see what Nick has to say. State's response to defendant's motion to preserve and produce specific evidence. Now comes the state of Indiana by prosecuting attorney Nicholas C. McClellan and respectfully asks the court to deny the defendant's verified motion to preserve and produce specific evidence and their motion to set this matter for hearing in their entirety. The state would ask the court to consider the following. 1. That as the court has already outlined in its February 14, 2025 order, that there is no authority for the defense to request that the evidence be preserved by the state, and the state would ask the court to deny the same. 2. That the defense in their motion also asks the state to produce specific evidence demonstrating exculpatory evidence for the defendant. 3. That the state has outlined this in previous filings, but discovery is evidence in a case that the state intends to use at trial or evidence that tends to exonerate the defendant, referred to as exculpatory evidence. Not all information gathered in this investigation is discovery. 4. That most of what Ricci Davis told attorney Andrew Baldwin is false. 5. That attorney Andrew Baldwin had an opportunity to fact-check the information that Ricci Davis provided to him, but instead chose to put the information in a public motion without verifying its truthfulness. 6. That the state contacted the Department of Corrections and had the department send a list of all outgoing mail from Ricci Davis to the Carroll County Prosecutor's Office, said list herein attached as State's Exhibit 1. 7. That as the court can see from this list, Ricci Davis did not send the state 8 letters, he only sent 3 letters. 1 letter on October 4th, 2025, 1 letter on October 15th, 2025, and 1 letter on October 21st, 2024, all during or very near the trial of State Indiana versus Richard Allen. 8. That the state was able to recover 2 of the 3 letters sent from Ricci Davis, the letter sent on October 4th, 2024, and the letter sent on October 21st, 2025. Herein attached State's Exhibit 2 and 3. 9. That the letters sent by Ricci Davis are not exculpatory for Richard Allen and therefore are not evidence or discovery. That the letters in fact accuse Richard Allen of committing the murders. It is not exculpatory evidence for Richard Allen. It is inculpatory evidence for Richard Allen. 10. That the letter dated October 4th, 2025 is titled Information on Kagan Klein and Richard Allen. The letter goes on to implicate Richard Allen in the murders, stating that he set up the meeting with the girls. He's the one that killed the youngest girl, and that once the girls were killed, Richard Allen moved the bodies. 11. That in the letter dated October 21st, 2025, Ricci Davis states that Ron Logan, Kagan Klein, and Richard Allen are responsible for the murders. He goes on to state that attorney Andrew Baldwin is an ignorant lawyer who was hinting me to lie for him and his client, saying that I should know how it is, and that is in quotes. 12. That although the state has diligently searched all the evidence involved in this case, the state cannot locate or even verify the second letter sent from Ricci Davis was received by this office. 13. That James Winters did call the prosecutor's office on October 15, 2025 and near October 21st, 2025 to verify that this office had received the letters sent by Ricci Davis. However, at that time, he did not indicate how many letters that Ricci Davis sent or when he sent them. He just called to confirm that the state had received some letters from Ricci Davis. Further, he indicated to this office that both Kagan Klein and Ricci Davis had been subpoenaed by defense to testify at the trial against Richard Allen. 14. That the state's response to the motion to correct error, that the state referred to the evidence that Ricci Davis supplied to attorney Andrew Baldwin as not matching the physical evidence found at the scene. The state therefore finds the information that Ricci Davis supplied is not credible. 15, that there is zero evidence found in the investigation that Ron Logan and Kagan Klein knew each other or shared or exchanged child pornography. 16, that the state was able to obtain recent communications between Kagan Klein and various civilians where Kagan Klein denies the allegations set out by Ricci Davis, herein attached as State's Exhibit 4. 17, that further in these text communications, Kagan Klein states that Ricci Davis is an idiot. I've only talked to him maybe 2 times. He's one of those guys in prison that tries to write all different prosecutors and get time cut on people's cases. It's laughable. Kagan reiterates this point in several of the responses that he texts. That 18, that as the court can see from State Exhibit 1, Ricci Davis did send several other letters out to other attorneys, which adds credence to statements that Kagan Klein made about Ricci Davis's behavior. 19, that attorney Andrew Baldwin could have requested this information from the Department of Corrections to verify or debunk Ricci Davis's statement before he made his filing, but chose to file the motion without verifying the allegations. 20, that attorney Andrew Baldwin, by his own admissions, interviewed Ricci Davis on March 27, 2024. 21, that attorney Andrew Baldwin had every opportunity before trial to depose Ricci Davis and had every opportunity to call him as a witness at any hearing or at the trial and chose not to. In fact, from James Winter's statements to his office, Andrew Baldwin had in fact subpoenaed Ricci Davis to testify at the trial for Richard Allen. 22, that attorney Andrew Baldwin now wants to present these statements from Ricci Davis as irrefutable proof without any evidence or corroboration to back up the statements. 23, that Ricci Davis's statement to attorney Andrew Baldwin did not match the statements that he made in the letters that he sent to the state. In those letters, he does not say Richard Allen is innocent or not involved. Quite the opposite. He says Richard Allen participated in the murders and is guilty. 24, that evidence that contains allegations that the defendant is guilty with no proof of those allegations is not exculpatory evidence and therefore does not have to be turned over to the defense. 25, that there is not a video interview of Ricci Davis that exists within discovery or is within the state's possession. 26, that even if this was evidence the defense wished to use at trial, it was not newly discovered evidence. The defense knew Ricci Davis had interviewed him, had subpoenaed him for trial, and chose not to present the evidence to the court. 27, further, as the state has mentioned in previous responses, any information pertaining to Ron Logan or Kagan Klein falls under the state's motion in limine concerning third-party motive. The defense had 3 days to present evidence to meet their burden for third-party motive. They mentioned Ron Logan but failed to meet their burden with the court. They chose not to present this evidence in that hearing. They also did not present this evidence when they renewed their motion during the trial. This now seems to be an effort by the defense to use this motion to circumvent their burden concerning third-party motive. 28. That none of the evidence that the state has gathered from Ricci Davis is exculpatory, nor is it discovery. 29, that this motion seems yet another attempt by attorney Andrew Baldwin to push a certain narrative to the public, specifically the online world. He seems to file these types of motions with very bold allegations that he neither verifies the information nor does he present any evidence to back up the statements. 30, that it is unfortunate that motions by the defense in this case have come to the point where they present statements from an inmate as a fact without any legal evidential support. Wherefore, the state of Indiana, by prosecuting attorney Nicholas C. McClellan, respectfully requests this court deny the defendant's motion in its entirety without a hearing and or other just and proper relief in the premises. The state affirms under the penalty of perjury that the above is true and accurate to the best of the state's knowledge. Nicholas C. McClellan, attorney. Okay, let's recap. And first of all, let me say I'm sorry for being so aggressive on this reading, but I just watched a basketball game that didn't go the way I wanted it to, and I've had far too much caffeine today, so I'm sorry. So I have said in the last video that information that's not exculpatory to the defense and does not, is not part of discovery, does not have to be in the file given to the defense. And that's what we see here. And the other thing is that I've told people to be patient, because just because the defense says or Ricci Davis said something happened doesn't mean it has. We have to wait to see the actual proof. So now we see that what Ricci said was not true. Where is the information that Ron Logan supposedly said it was a box cutter back in 2017? Okay, so that's where we are, folks. And I hope that people are starting to see what's going on here. And I hope that we can move on to Richard Allen's new attorneys filing the appeal, going through that process, and moving forward. Okay, that's it. We'll see you next time on Deb's True Crime Notebook. And I know there's going to be a next time. Don't forget to like, subscribe, share this in your group and with your friends. Follow my account. Ring the bell for all notifications. Check out the community section, which is now called Post on YouTube. So check that out periodically. I'd like to communicate with you guys there. And leave me a comment. You know how I love to hear your thoughts and ideas. And I'm sure we're going to have some really good ones on this. We'll see you next time.